If I asked you to tell me the most historically important US presidents, you could probably name a few of the classics. How about Chief Justices? Well, if there's one name you should know, it's Marshall. And Taft doesn't count, he was president first.
So Marshall's kind of one of those American, by his bootstraps, folk heroes. He had wealthy family members, which would later turn out to be quite handy because, it's hard to fashion the government of a nation with bootstraps alone. But he himself was log cabin certified and made most of his money on his own working as a surveyor for an English gentleman. Then the revolution happens, he does a brief stint in the army, goes to college, and by the time he's 31, he decides to open up his own law firm. Or rather, buy out his cousin since he was busy being the governor of Virginia. A few years later, the President of the United States, George freaking Washington, comes knocking and says, "Hey, wanna be state attorney? Already cleared it with the Senate. It's yours." "Nah, I'll pass." A few years later, Attorney General, chief lawyer of the whole country. What do you say? "Thanks, but no thanks. I've got a good thing going here." And he totally did. He was arguing before the Supreme Court by the next year. A few years later, and Adams is on the way out of office, but before he goes, he decides to give the bird to Jefferson and his incoming Democratic-Republican administration by establishing circuit courts around the country populated almost entirely by Federalist judges. The Supreme Court also found itself down one Chief Justice, and surprise, surprise, Adams nominated forgotten founding father John Jay because he had served as Chief Justice before. But Jay said, "That's lame. The judicial branch is lame. We never get to do anything fun." At this point, Adams has 2 months until Jefferson comes into office and he needs to find someone fast. "Chief Justice of the Supreme Court, you can be the most prolific adjudicator in the entire country for the rest of your life, just please." Now you're talking. Now Marshall knew that the judicial branch was lacking in power, by far the flimsiest of the three branches, but it was just powerful enough to make itself powerful. Right off the bat, he did away with the practice of each judge writing their own opinion. There would be one majority opinion, and as much as he could help it, it would be his. Once Jefferson steps into office, he sees fit to return the bird and fires a whole bunch of the judges that Adams had hired. Well, one of them sues, and Marshall tells him, "Oh, gee, I'd love to help you, and for the record, you're totally right, but I'm not allowed to tell politicians to do their job. But the Judiciary Act of 1789 has just been declared unconstitutional. Good day." But in a dramatic twist, by yielding to the Jefferson administration, he actually gave the Supreme Court more power by giving it the ability to strike down laws passed by Congress if they conflicted with the Constitution. How did that work exactly? What was Marshall's actual legal reasoning?
Well, guess what, Jack? I just made a video answering all of those questions.
Why, if it isn't Mr. Beat from the excellent historical YouTube channel of the same name, what an unexpected coincidence. That video sounds like a perfect follow-up to this one. In fact, I'm willing to bet it'll show up in the end card, so you good folks at home be sure not to miss it. Now, for the record, Marshall didn't invent judicial review, but it was he who declared the Supreme Court could use it. Today, it's the court's calling card. All the famous cases, Obergefell v. Hodges, Roe v. Wade, Plessy v. Ferguson, Lemmy v. Kurtzman, they all had to do with whether or not laws were constitutional. But that wasn't the only way he fought for the judicial branch. The Jefferson administration had other means of removing judges. Specifically, they attempted to impeach Marshall's fellow Justice Samuel Chase for judging with political bias, particularly political bias they didn't agree with. Obviously, that trial didn't go in front of the Supreme Court, but Marshall made an awfully convincing case for Chase, and his acquittal set a precedent for thinking twice before impeaching a judge. Basically, making Jefferson stress out was Marshall's whole career. When Jefferson was dying to have Aaron Burr found guilty of treason, not for shooting Hamilton, mind you, he got off scot-free for that one. Not only did Marshall let him off the hook on account of a complete lack of evidence, he even subpoenaed Jefferson while he was still in office. Old Tommy tried to pass it off as, "Fine, I'll give you the documents, but not because you told me to." Probably because he would have lost that battle if he tried. Then in Fletcher v. Peck, Marshall declared, "Guess what? State laws can be unconstitutional too." Which, not surprising, but not great for state power. Luckily, Congress passed the 11th Amendment back in '95, so no one could go as far as to sue a state, but that doesn't mean you can't sue state officials. Boom! Osborne v. Bank of U.S., 1824. So after the first 3 decades of the 1800s, Marshall had made the Supreme Court a force to be reckoned with. But by the 1830s, Marshall was the only man left from his original Supreme Court cohort, and he didn't have the same clout among the new judges, every single one of whom was a Democratic Republican. And worst of all, he's up against Jackson. A rivalry with Jefferson is one thing. You're going up against someone who doesn't want his branch of the government to be too powerful anyway. But whereas competing with Jefferson is like playing chess, playing with Jackson involves a lot of picking up pieces off the floor. The Marshall Court made a decision regarding Indian nations that Jackson didn't like, and he responded with, "Well, if you're so smart, why don't you try enforcing your interpretation?"
I mean, he probably didn't say it like that, but he completely disregarded the court's order and refused to enforce the law, instead opting to settle the particular case privately. People complain about politics being a mess today, but let me tell you, it is nothing compared to the antebellum years. But ultimately, it was Andrew I Am the Law Jackson who had the last laugh. Marshall found himself needing a second surgery shortly after the aforementioned court decision, and, well, this was the 1800s, it's a miracle he'd survived one surgery already. He died in Pennsylvania, and Jackson wasted no time appointing as his replacement Roger Taney, most famous for deciding that black people weren't citizens and had no right to sue. After Marshall's death, it's alleged that the Liberty Bell rung out in his memory, at which point it cracked straight along the side, but that's mostly apocryphal. Some say it was on George Washington's birthday in 1846. All we know is it was somewhere around that point of history. The point is, Marshall dead, people sad. The end.
Bloody hell, that was a fast turnaround. I'm exhausted. A warm welcome to everyone coming from Mr. Beat's channel. I've got a couple other videos on American history for you, as well as a pope who committed genocide. Fun times. As for everybody else, go watch Mr. Beat's video on Marbury v. Madison. His series on Supreme Court cases is excellent, and I've gotten distracted watching them too many times during the making of this video. Au revoir.